Lakers fan files lawsuit against LeBron James over Decision 2.0 teaser, plans to serve superstar at live game. Los Angeles. As the 2025-26 NBA season approaches, a unique off-court controversy has emerged involving LeBron James, the Los Angeles Lakers' four-time NBA champion and global sports icon. The incident centers on a lawsuit filed by a fan, Andrew Garcia, who alleges that James' recent promotional teaser misled ticket buyers into spending significant sums on the final home game of the season. Garcia has stated that he plans to serve James at Crypto.com Arena during a Lakers game if personal service at the player's Beverly Hills residence is not possible, setting up an unprecedented legal scenario in professional sports. The teaser that sparked controversy earlier this month, James released a promotional video that many interpreted as Decision 2.0, referencing his 2010 televised announcement when he left Cleveland for Miami. Fans speculated that James might announce retirement or another landmark career decision. The teaser quickly went viral, spreading across social media, sports networks, and news outlets, and created a surge in ticket demand for the season finale. Reports indicate that some fans paid over $500 for seats, anticipating a historic moment in NBA history. Ultimately, the teaser revealed itself to be a marketing campaign for Hennessy Cognac, rather than any basketball-related announcement. While legal experts note that James' promotion did not constitute intentional deception under California law, fans like Garcia felt financially misled, resulting in the small claims lawsuit now pending in Los Angeles County. Andrew Garcia's lawsuit and proposed service. Garcia's lawsuit asserts that the promotional content created a misleading impression that artificially increased ticket demand, causing him to suffer financial harm when the announcement was unrelated to James' career. Garcia shared publicly in small claims, "I cannot serve his representation. Even if they are willing to accept the process, it's a California guideline. If he's unwilling to get served at his residence, the Beverly Hills address that's listed on the filing, I'm going to have a process server serve him at Crypto.com Arena during a game. This is not going away." The legal maneuver to serve a high-profile athlete during a live event is rare, raising questions about logistics, security, and compliance with California small claims procedures. If executed, it could become a historic moment in sports law, highlighting the challenges of holding celebrities accountable through legal avenues. LeBron James, career and cultural influence. LeBron James, now 40, has spent over 2 decades establishing himself as one of the most accomplished and influential athletes in history. A 4-time NBA champion, 4-time league MVP, 19-time All-Star, and 2-time Olympic gold medalist, James has excelled both on the court and off. Beyond basketball, he has leveraged his platform for brand partnerships, media production, philanthropy, and social advocacy, cultivating an international profile that few athletes achieve. James' career has been punctuated by high-profile public moments, including his first decision in 2010, numerous endorsements, and interactions with media personalities. His ability to drive attention, both for basketball-related announcements and off-court ventures, has created an environment where fan expectations often intersect with marketing campaigns, sometimes with unintended consequences. Fan reactions and public discourse. Social media erupted following the teaser, with fans posting a mixture of humor, frustration, and incredulity. Many commented on the inflated ticket prices for the final home game, while others criticized James for the perceived ambiguity of the promotional content. Some praised Garcia for taking legal action, arguing that fans should have recourse when public figures appear to mislead consumers. Others questioned the practicality and enforceability of serving a superstar athlete at a public event, highlighting the unusual nature of the case. Sports media outlets have extensively covered the lawsuit, emphasizing both the novelty of serving James during a game and the broader implications for promotional transparency. Analysts have noted that, while small claims filings are common in other sectors, cases involving globally recognized athletes remain exceedingly rare due to logistical challenges and security concerns. Legal context. Small claims in California. Small claims courts are designed for simplified resolution of disputes up to $10,000 for individuals. Plaintiffs are permitted to represent themselves, but the defendant must be properly served with the complaint. Service of process typically requires personal delivery, although alternative methods exist if the defendant cannot be reached. In cases involving high-profile individuals, plaintiffs may encounter unique obstacles, such as restricted access to residences or tightly controlled public appearances. Garcia's intention to serve James at Crypto.com Arena underscores both the flexibility and complexity of small claims procedures. Legal experts indicate that executing service at a public event would require careful planning to comply with state guidelines while ensuring the process is legally valid. This case could set a precedent for future small claims involving celebrities or public figures with limited accessibility. Historical comparisons, athlete lawsuits and fan disputes. While rare, professional athletes have occasionally been involved in legal disputes initiated by fans or consumers. Examples include lawsuits related to ticketing misrepresentation, promotional campaigns, and marketing initiatives that allegedly misled purchasers. In many instances, these cases highlight the tension between entertainment-driven marketing strategies and the legal rights of consumers. High-profile lawsuits involving athletes typically involve contractual obligations or incidents occurring at games or promotional events. Garcia's case is distinct in that it centers on perceived misrepresentation through a marketing teaser, rather than conduct during a live sporting event or contractual dispute. The potential service during a game adds an unprecedented element, elevating public interest and media coverage. Ticketing, marketing, and the NBA ecosystem. The NBA operates in a complex ecosystem where ticket sales, promotions, and athlete branding intersect. High-profile players like LeBron James wield significant influence over consumer behavior, with promotional campaigns capable of driving demand and creating market fluctuations. While legal liability is generally limited, campaigns that create false impressions or mislead consumers can attract scrutiny, particularly if they result in financial loss. The Hennessy teaser illustrates the potential risks associated with celebrity-driven marketing. Even without intent to deceive, the ambiguity surrounding the promotion generated consumer expectations that led to legal action. Teams, athletes, and sponsors must carefully calibrate messaging to minimize potential disputes while maximizing engagement. Potential implications for the Lakers and NBA. The lawsuit may have implications beyond the immediate claim. Should Garcia succeed in serving James during a live game, the incident could influence how the NBA and its teams structure promotional campaigns, particularly those involving superstar athletes. Policies regarding ticket sales, marketing communications, and public accessibility may be reassessed to prevent similar disputes. For the Lakers, this legal matter coincides with the team managing LeBron James' injury status. James is expected to miss at least 3 weeks following a minor injury, adding complexity to early season planning and media management. The team must balance on-court preparation with the potential distraction posed by the ongoing legal and public relations developments. Broader cultural significance. The case illustrates the evolving relationship between superstar athletes, fans, and media. In an era where social media enables instantaneous communication and direct engagement, athletes like LeBron James must navigate heightened scrutiny, consumer expectations, and the potential for legal repercussions. This dynamic extends beyond basketball, reflecting broader cultural trends in celebrity, marketing, and fan interaction. Experts in sports law and marketing note that the lawsuit raises questions about the responsibilities of public figures in managing promotional content, the limits of consumer protection, and the intersection of entertainment and legal accountability. How the case unfolds could influence future practices for athletes, teams, and leagues seeking to balance engagement with legal risk management. Conclusion: navigating public, legal, and athletic challenges as the 2025-26 NBA season unfolds, attention will focus not only on the Lakers' performance and LeBron James' on-court contributions but also on the outcome of Garcia's lawsuit and its broader implications. The intersection of celebrity marketing, fan expectations, and legal accountability highlights the complexity of modern professional sports, where off-court narratives can have as much impact as on-court performance. Garcia's case, while small in legal terms, carries outsized symbolic weight, representing the ability of individual fans to challenge perceived misrepresentations by globally recognized figures. The Lakers and James now face the dual challenge of maintaining competitive performance while navigating unprecedented legal and public relations issues. How this scenario resolves, whether through successful service, legal dismissal, or settlement, could influence NBA marketing campaigns, fan engagement strategies, and the broader relationship between athletes and consumers. In the meantime, all eyes remain on James, the Lakers, and the unfolding drama both on the court and in the legal arena.